Lesson: Choice of law and forum in international contracts. Choice of law and forum in international contracts are pivotal considerations that directly impact the enforcement, interpretation, and overall success of cross-border agreements. These elements are critical for ensuring legal predictability and minimizing risks associated with international transactions. Professionals involved in drafting and negotiating international contracts must adeptly navigate these complexities to safeguard their clients' time, interests, and augment the efficacy of contractual arrangements. The following discourse provides a detailed examination of choice of law and forum selection, offering actionable insights, practical tools, and frameworks for professionals to implement effectively. Choice of law in international contracts involves selecting the jurisdiction whose legal principles will govern the contract. This decision determines the applicable substantive and procedural rules influencing contractual performance, dispute resolution, and enforcement of rights. Factors influencing choice of law include the nature of the transaction, the parties' domiciles, and the jurisdiction's legal systems. Notably, the Rome I regulation provides a comprehensive framework for determining the applicable law in contractual obligations within the European Union, emphasizing party autonomy while ensuring legal certainty. Incorporating a choice of law clause is a strategic tool that parties can use to specify their preferred legal system. This clause should be explicit, unequivocal, and consistent with the contract's objectives to avoid ambiguity and litigation. Professionals should advise clients to consider jurisdictions with well-established legal systems, robust contract enforcement mechanisms, and favorable substantive laws. Additionally, they should evaluate the jurisdiction's public policy and mandatory rules, which may override the chosen law. Forum selection, on the other hand, involves determining the appropriate venue for resolving disputes arising from the contract. A forum selection clause designates the courts or arbitral tribunals that will have jurisdiction, thereby enhancing predictability and minimizing forum shopping. The Hague Convention on Choice of Court Agreements, applicable in certain jurisdictions, underscores the enforceability of exclusive choice of court agreements, thus promoting international judicial cooperation. Professionals should guide clients in selecting a forum that offers neutrality, expertise, and efficient dispute resolution processes. Considerations include the forum's procedural rules, language, costs, and enforcement of judgments or awards. Arbitration, as an alternative to litigation, provides flexibility, confidentiality, and cross-border enforceability under the New York Convention. A well-drafted arbitration clause should specify the governing rules, seat of arbitration, and language to mitigate ambiguities and procedural disputes. Practical tools for addressing choice of law and forum challenges include contract negotiation checklists and risk assessment matrices. A negotiation checklist ensures that key issues, such as choice of law and forum, are duly considered and documented during contract negotiations. This tool facilitates informed decision-making and prevents oversight of critical terms. A risk assessment matrix, on the other hand, evaluates potential legal, financial, and reputational risks associated with different jurisdictions. This matrix assists professionals in weighing the pros and cons of various options, thereby optimizing client outcomes. Frameworks for effective implementation of choice of law and forum clauses involve a step-by-step approach. Initially, professionals should conduct a thorough analysis of the transaction's legal, commercial, and geopolitical context. This analysis informs the selection of appropriate jurisdictions and dispute resolution mechanisms. Subsequently, they should engage in comprehensive negotiations to align the parties' preferences and interests. Drafting precise and enforceable clauses necessitates careful attention to linguistic clarity, legal validity, and alignment with international conventions or regulations. Case studies illustrate the practical application and implications of choice of law and forum clauses. In the case of Akai PT Ltd v. People's Insurance Co., the Australian court enforced a choice of law clause favoring Chinese law, highlighting the importance of respecting parties' autonomy and contractual stipulations. Similarly, the Supreme Court of Canada in Zedai Pompey Industry v. ECU Line NV upheld a forum selection clause designating Belgian courts, reinforcing the principle of judicial deference to contractual agreements. Statistics underscore the significance of choice of law and forum in international contracts. A survey by the International Chamber of Commerce found that 82% of respondents prioritized choice of law clauses in their contracts, while 78% emphasized forum selection clauses. These findings demonstrate the widespread recognition of these clauses as essential components of international contract management. In conclusion, choice of law and forum in international contracts are critical determinants of contractual success and risk management. Professionals must leverage practical tools, frameworks, and strategic considerations to navigate these complexities effectively. By incorporating explicit clauses, conducting rigorous analyses, and aligning with international conventions, they can enhance legal predictability, minimize disputes, and optimize client outcomes. The case studies and statistics presented herein further underscore the practical significance and widespread application of these principles in international contract law.